Related cases of Carl J. Willis II versus Kimberly S. Willis, case number S10F1357, and Kimberly S. Willis versus Carl J. Willis II, case number S10F1358.
G. Clyde Deagle III, representing Carl J. Willis III, Kimberly S. Willis, appearing pro se.
Good afternoon, Honorable Justices. I'm Clyde Deagle. I represent Carl Willis in his appeal from the Fulton Superior Court's divorce decree as to child support, a case where equally shared physical custody of a child was awarded to both parties. We are claiming error in the trial court's improper distribution of the presumptive amount of child support by awarding all of the child support to Mrs. Willis all of the time, and none of the child support to Mr. Willis, even though each has custody and financial responsibility for the child 50% of the time. This ruling was defeative of the statutory purpose of child support to directly provide child support for the child's benefit, which would have been available to him as in an intact household or an intact family, to provide the presumptive amount of child support for the direct benefit of the child during the respective period of each party's custody, with the child support necessarily following the child. Instead, the trial court did not provide any of the presumptive amount of child support to the appellant father during his 50% of custody time, but awarded all of the child support to the mother even during the father's custody, as if the mother were the sole custodian. It provided for no child support obligation of the mother when the child is with the father, despite the statutory setup where the presumptive amount of child support is supposed to represent the contributions of both parties. This improper distribution of the presumptive amount of child support obviously deprives the child of the benefit of the intact household support for half the time when he's with the father. It punishes the father by not providing for any child support to the father during the period of his responsibility, and thus also punishes the child. It unjustly enriches the mother by requiring no child support contribution from her, but awarding all the presumptive amount of child support to the mother during the father's custody time.
How old is the child?
I'm sorry, sir?
How old is the child?
2.5, sir. The error of the trial court was to defeat rather than to fulfill the statutory purpose and the state policy regarding child support as being for the benefit of the child. The end result was to provide no child support for the child's benefit for half the time, rather than providing support for the child's benefit all of the time. We ask that this court overrule the trial court's error in this regard, provide for the appropriate pro rata division of the child support between the parties in order that the child might benefit from that support all of the time, not just half the time. It's simply a matter of appropriate distribution. The court also erred in two other particulars by adding a provision following its announced closing of the evidence in trial ruling, erroneously based on a post-trial non-evidentiary outburst and comments by Mrs. Willis claiming drug use and current drug use not in evidence, by the courts indefinitely requiring future hair follicle testing. This is based on non-evidence. And the length Mr. Willis will always have to wear his hair.
Let me ask you about one other thing.
Yes, Judge.
Before you get in there. If the court had granted joint custody, which would and had given her child support, is it still your contention that an award of joint custody would have required the trial court to order that she pay him a certain amount of money?
Judge, my view is, and I think that this is my view from what I understand, the way I understand the law, the presumptive amount of child support is figured based on the joint income of the parties to determine what amount of total child support is supposed to be contributed by both parties, that is to say, hers and his, to create a total presumptive amount to directly benefit the child as if the child were in an intact household. When the child support worksheet is worked out, the amount of the, in this case, the mother's contribution and the father's contribution each appear on the bottom of the first page of the worksheet. The total of those two being the presumptive amount of child support. If the mother had the child all the time, full custody, then her portion of the child support would be deemed to be kept by her to be used for the child, and the father's portion, the presumptive amount of child support, would be something he would have to pay to the mother in order that throughout the mother's entire period of 100% custody, that child would have the benefit of the total presumptive amount of child support. However, where each party has custody half the time, then that presumptive amount of child support, total presumptive amount of child support, should be divided in half, just as the custody is divided in half. She would only owe half of what she would otherwise owe. He would only owe half of what he would otherwise owe. Then you would wash what she owes against what he owes, and he would owe her the balance on a regular basis. All it does is provide that the presumptive amount of child support go to the child for the direct benefit of the child during the entire period of the child's custody, half the time with the father, half the time with the mother. Not just take all the child support and give it to one of the parties with only 50% of the custody and not give any or provide for any to go to the other party with 50% of the custody.
What will happen when the child goes to school? One parent would definitely have the child more than the other then, would he not?
No, it's 50%, half custody. They alternate weeks. He has a week, she has a week. So in effect, he has 50% of the time and 50% of the responsibility for the child, just as she does. So that the problem here is the distribution of the presumptive amount to comply and fulfill the statutory purpose of child support. May I
go right
briefly? Okay. The court's ruling on the hair follicle testing and the length that Mr. Willis would have to wear his hair came after the trial was finished, after the evidence had been concluded, after the court had made a ruling. Then Mrs. Willis made an outburst about what if he takes drugs or some such thing as that. And the court said, okay, erroneously, says, okay, then what we're going to do, based on this non-evidence, is require hair follicle drug testing and Mr. Willis indefinitely, no limitations, and Mr. Willis will also always have to wear his hair a certain length. No evidence, no opportunity, or really a reason for Mr. Willis to comment because it was in the context of non-evidence and followed the conclusion of the trial in the court's ruling. This was also an erroneous open-ended ruling with no time restriction and an erroneous contemplation of unknown future events with reference to any drug involvement, if any, as to which no relief had been sought, which did not exist, which might never exist, and as to which unknown no relief was appropriate. Trial court also erred in
there was no evidence at all about the drug use?
There was some testimony by Mrs. Willis that Mr. Willis had used marijuana at some point in time. The evidence was that the parties had not been together so that Ms. Willis would have no knowledge for over a year and a half, and the testimony by Mr. Willis was there was no drug use, no current drug use.
Wasn't there something in the record about he had stopped using drugs sometimes prior to that time? 3 or 4 months?
That's correct. That's correct. Several months prior. I believe it was 10 months prior.
So there was some evidence about drug use?
Prior drug use, no present drug use. So and I understand your question, I appreciate that, but what the judge did was to say, well, we don't know about any drug use, but since you're talking about drug use, let's just cover all the bases. And Mr. Willis, you just will forever submit yourself to drug testing. No time limitation, no restriction. And you also have to wear your hair a certain length so we can have a certain kind of drug testing based not on what was in the evidence, but on Mrs. Willis' post-trial comments to the court with no opportunity as I say, all reason for Mr. Willis to comment since it was not evidence. The trial court also erred in its attempt to control both the parties beyond the judgment by subsequently adding to its ruling. Later on, we get this after the ruling when the judgment comes down, that the parties were obligated to seek counseling from a certain counselor, a specific counselor, if and when they could not agree on any issue as to which the court had already given final decision-making authority to each party. This erroneously contemplated future problems that did not exist at the time of the trial and was defeative of the purpose of the decision-making authority already provided by the court to each party. Even Ms. Willis is questioning and claiming that this was error. Finally, Mr. Willis seeks maximum sanctions by this court against Ms. Willis in both cases, including attorney's fees for her violation of various rules.
Sorry, sir, your time is up.
All right, thank you so much.
Ms. Willis?
Appreciate it, gentlemen.